I want to talk about the Mars rule a little bit. I don't know how many of you have been following the Mars rule, but it's been quite a roller coaster ride. So I want to just give an update as to where we stand at this point. There have been some technical clarifications from HUD regarding RESPA, some rules that went into place a couple of years ago, and they've just issued some clarification points. So I'm going to go over those briefly. And then a couple of issues that we want to watch. You've probably heard a lot about the QRM, the Qualified Residential Mortgage, a hot topic right now. And I want to talk about how that plays into perhaps some seller financing issues that we also need to be watching right now. How many of you have been following the Mars rule? How many of you know what the Mars rule is? Okay, a few people know. Okay, the Mortgage Assistance Relief Services Act. It was a regulation put in place by the FTC, and it was targeted at mortgage assistance relief companies. So what these companies would do is they would come in and they would talk to distressed sellers or homeowners about how to keep them in their homes if they were looking at foreclosure type situations. And they would charge fees sometimes up front, and there was a lot of unscrupulous practices going on. They would take money and then they wouldn't actually do what they were supposed to be doing, or they wouldn't. They make promises to the homeowners that they really couldn't fulfill. And so the FTC came up with the Mars rule. Now, when they were coming up with the Mars rule, the NAR was very much involved in the drafting of that regulation, or input in the drafting of that regulation, and wanted to see an exemption in there for short sale brokers. And the FTC refused to put those exemptions into the rule. They put a footnote in there saying that it probably wouldn't apply to short sale brokers, which really wasn't quite enough, but it's all we had at the time. So then the rule comes out, and we're thinking we're going to get some guidance from the FTC that exempts short sale brokers, and instead the FTC takes the position, and if you look at the definitions under the Mars rule, short sale brokers were encompassed within that, and the FTC takes the position that they are going to enforce the rule against short sale brokers. So NAR issued that statement, and at the same time they continue to work with the FTC to try to get short sale brokers exempt. Right before, a couple of Random Voices ago, for those of you who read the Random Voice, I had created an article on the Mars rule, and it said that you guys were going to have to comply with the Mars rule. And about 2 days, and actually the day before it went to print, we got an information from NAR Counsel that they had finally negotiated with the FTC to get you guys exempt. They didn't have anything. I had an email from NAR Counsel, but I did not have anything official from the FTC at that point. I went ahead and changed the article in the Random Voice to reflect the new position. And not more than 2 weeks after that, the FTC did a 180 and decided that you did have to comply. They were supposed to go to NAR's mid-year conference. They pulled out. NAR had submitted a bunch of Q&As for them to answer, and they wouldn't answer them. And we were back to you guys as short sale brokers had to comply with the Mars rule. And the main issue with that would have required you, number one, not to charge any upfront fees for Mars services, which typically I know you guys don't do for negotiating with the bank. It's just part of the deal. But the more complex and more concerning issue of the Mars rule for you guys was that there's a disclosure requirement. A disclosure requirement if you're doing general advertising that you do short sales. A disclosure requirement at the time that you take a short sale listing or learn that it's going to be a short sale, and then another third disclosure requirement at the time you get the lender approval letter back from the bank and you're submitting it to the owner or the seller of the property. So these disclosures were the problem, mainly because the way the FTC had written the language, it didn't apply to you. It really didn't. It said things like that I'm going to charge you this much money for my short sale negotiations. You don't have to pay me if I don't get what you want, the desired result. You don't have to pay me until after everything is signed and done, these kind of things. And in trying to make those work with our listing agreements, there were all of these contradictions that would just thoroughly confuse an owner. So anyway, NAR continued to work with the FTC, and we finally got a letter from the FTC saying that short sale brokers were exempt from the Mars disclosure requirements and in any of the Mars rules, as long as you're a licensed broker in good standing, you're in compliance with the laws governing the brokers within the state, and you're assisting or attempting to assist customers or clients in a short sale situation. Very important, however, not to misrepresent to your customer or client why you're assisting them, because if they find out that you've misrepresented anything, all of a sudden you're back into the requirements of the MARS rule. So if you end up, I mean, it's kind of after the fact. You're proceeding along as if you're not included in here. You make a misrepresentation. The FTC finds it doesn't even have to be malice involved. It doesn't have to be an intentional misrepresentation. It has to be a misrepresentation. And all of a sudden, you're back into the requirements of the MARS rule. So what is a misrepresentation as far as the FTC is concerned? Well, obviously, it's something that's misleading or deceptive. For example, if you promise you can get the seller a certain price for a short sale, I can guarantee that the bank is going to settle this, and sell it, do a short sale for X number of dollars. That's, in their opinion, misrepresenting the facts, unless you have something in writing from the bank saying that that's what they're going to take on the short sale. If you are claiming to be an expert in short sales, but you're not an expert in short sales, that's a misrepresentation that's going to get you in trouble. Misrepresenting the results you can obtain. For example, the bank is not going to go after you for a deficiency judgment after this, or require you to pay the deficiency in the short sale. Unless you have that in writing from the bank, don't make that representation. I know that typically banks are not, may not be doing that, might not be proceeding or going after borrowers and for this deficiency. But it is within their right. We are a state that allows them to do that. So
how long does that last?
How long does what last?
The right to go after deficiency.
What is the statute of limitations on that?
6 years.
I would probably say 6 years because it's based on a contract that they signed, and so I would say 6 years. So typically, and that's, we don't see a lot of that in foreclosure situations as well. They can go after them for deficiency, and we're not seeing a lot of that, but we can't make promises that it won't happen because it's certainly their right to do so. So unless you have it in writing from the bank saying they're not going to do it, don't make that representation. So what about that period of time where we were supposed to be complying and probably a lot of people were not complying? Most likely nobody's going to come after you for that period of time. You can receive an upfront fee now for MARS services as in a short sale situation. So if you do charge an extra fee or a separate fee for negotiating with the bank in a short sale situation, you can charge that fee up front now. There's a new bureau or a new division called the Consumer Financial Protection Bureau, and it was set up under the Frank-Dodd Act to do a lot of regulation in regards to mortgage lenders and mortgage loans, and they are taking over. They have taken over the enforcement of this rule, the MARS rule. So of course that makes us a little bit nervous in the sense of, are they going to do something differently than what the FTC has done? But what they have issued, the Bureau has issued a statement saying that they are going to follow the FTC's lead for the most part. If the FTC says that short sale brokers are not included, then they're going to follow that and continue to not enforce the rule as to short sale brokers as long as they comply with these provisions. Also, there is a provision under the rule that allows attorney generals to bring claims under the MARS rule. An attorney general could decide that they wanted to enforce the MARS rule against short sale brokers. However, if that should happen, they have to let the FTC or now the Bureau know that they're planning on doing that, and then the FTC or the Bureau would intervene in the action, in the court action, and would explain to the court that they don't see it that way, and they would state their position. So I doubt that the attorney generals are going to take a different stance than the division that actually promulgated this rule. However, we are continuing, and I say we, NAR, the realtors are continuing to work with the Bureau. We'd like to see the exception for short sale brokers actually built into the rule or regulation, and so they continue to work with the Bureau to see if we can make that happen. Also, under MARS, there is no private right of action. So if a borrower says, I feel like somebody violated the MARS rule and I want to bring an action against a broker for doing that, that is not available to them. They would have to go to the district attorney or the attorney general. Okay. Yeah.
Attorneys fall into this, right?
Yes. If they're doing loan, the negotiation, exactly.
And if you're a broker and representing the seller in a short sale situation, and the seller has engaged an attorney, and you're having to follow the attorney's advice, what's your exposure on that?
Well, I think as long as you're a broker in a short sale situation, you don't have any exposure. If the attorney has done the assessment and determined that they fall under the rule, given what they're doing in the transaction, then they would be obligated to comply. And if they didn't, that's going to fall on the attorney. That's not gonna come back on the broker. Okay, I don't foresee that as being a problem. Okay. So you guys can keep an eye out for the Mars rule. We did send out an announcement after the random voice came out. We sent out an announcement out to all the QBs about the new position the FTC had taken. We hadn't created all these forms for the longest time because we thought we were going to be exempt from them anyway. And then when they wouldn't actually come down and put it on paper, we created all the forms and the information sheet and all of that stuff. And we actually got it approved, and it was with zip forms when I got the notice that we weren't going to need to comply. So everything got pulled. So like I said, it's been a bit of a ride. I think things have stabilized out, and I think we're all in a safe zone right now as far as the Mars was concerned. But in the event that you hear certain things out there, you can put those concerns to rest. Again, just make sure you're not making promises you can't keep when it comes to short sales, okay?
Is that misrepresentation just relative to clients, or could it be to other brokers? For instance, if a property is in the MLS as a short sale when the bank hasn't really given permission for short sale, is that considered misrepresentation?
Well, the whole idea of the rule is to protect the customer client, but I could arguably see how that could be a problem because even if it's being relayed to, well, a couple things. It's being relayed to other brokers who are then going to relay that to their customers and clients. So ultimately, it is going to filter down to them. The other issue is depending on where it is. If it's in the general remarks section, for example, then the feed gets picked up to Realtor.com or other websites that provide the information to the general public where there's no other broker on the other side, then that could be a problem, yes. So think about your representations when you're making them, when you're putting them out there, where they're going to end up, who's going to be seeing them, and certainly make any, you want to disclose the possibility, but certainly don't say definitively if you don't know that that's the case. Yeah.
By definition, though, wouldn't it still be? I mean, even if it's not bank approved, if they're not going to be able to close unless the bank approves, wouldn't you need to disclose that it's a short sale?
Yes. Well,
I mean, I would think you'd err on the side of caution and call it a short sale even without bank approval, as long as you're not saying it's a pre-approved.
Well, I think that's exactly what you need to say is it hasn't been approved, or it hasn't been approved by the bank, but it appears to be, it's going to be a short sale.
Okay.
So some language that doesn't lead someone to believe that the bank has already approved a certain number, or even the short sale at all. So some language to that effect. Any more questions on the Mars rule?